divorce done in Ghana, so to speak, is it acceptable in the UK? If it is, under what condition?
Okay. Well, the question whether Ghanaian divorce is valid or acceptable or legal in the United Kingdom can be answered in twofold. First of all, if the English courts are looking at a foreign or overseas divorce, there are certain requirements that they look for. And this is set out in legislation, and it's the Family Law Act of 1986. Section 46 is what guides foreign divorces or overseas divorces. First of all, for the divorce to be accepted as valid in the UK, the person or the parties in the divorce must be, or one of them must be, a citizen of that country, or a person who is domiciled in that country, or a person who is habitually resident in that country. Remember that in the UK, our divorces prior to the 31st of December 2020 was the jurisdiction of the court was dictated by what we call the Brussels II jurisdiction, which is an agreement between all the European Union countries. However, since we left, that no longer applies. So most cases will be guided by the Family Law Act of 1986. So the typical example, in Ghana, we have two main types of divorce. We have dissolution under the Matrimonial Causes Act, and then dissolution under what we call the customary law and practices or religious dissolution. Now, I refer to the Matrimonial Causes Act because Section 42 of the Matrimonial Causes Act can also applies to customary law marriages. And also, I think Section 13 applies to marriage by ordinance.
Okay.
But we all know that the laws of Ghana, as prescribed by the Constitution, includes the Constitution, common law, customary law, usages and practices of particular people.
Okay.
So every Ghanaian national will have their personal law, which is dictated by the particular area that they come from. I mean, case law has set this out clearly. So if you are a Ghanaian, in addition to dissolving your marriage in court, and can I add that it is only marriage, well, marriage or ordinance marriage can only be dissolved in court, not at home.
Okay.
However, customary law marriages and Islamic marriages can be dissolved outside court. The courts have held that for a process to be accepted as an arbitration leading to dissolution of the marriage, it ought to follow certain procedures. One, that both parties voluntarily submitted to the jurisdiction or the powers of the family arbitration committee or group. Normally will be a man who's assembled, the woman's family and his family makes an allegation against the woman, mostly adultery, witchcraft, barrenness, stealing and other things. Those are some of the factors that the customary law prescribes for dissolution of the marriage. If the family tribunal, or for want of a better word, the family arbitration, concludes that the marriage is at an end, then prescription under customary law requires that if it's the woman who is dissolving the marriage, the woman must return the dowry to the man.
Okay.
If it's the man that is dissolving the marriage, then in addition to asking both parties whether they owe each other so that they can repay the debt, the man ought to pay her some form of compensation for her to go. Once you've gone through these processes, the accounts will say that she's powdered. Now, the word powder is not a talcum powder that we know. No. It is a particular substance that we call shiri. So she will be powdered in the local parlance, and that means that she's free to go and marry. There are very, very strong cases, as example, cases from the Upper West and Upper East regions and the Northern Ghana, which although they didn't go through the processes, Yet, because of particular acts of the woman and another man, it was accepted that the marriage was at an end. But in the UK, because they look at divorce through the eyes of two particular requirements under the Family Law Act, they would decide whether the divorce was obtained through a process and proceedings. Court proceedings will satisfy that test.
Right.
Or that it was obtained otherwise than by proceedings.
Okay.
So if your marriage was obtained otherwise than by proceedings, which is basically that West African dissolution of marriages or religious dissolution, we call the talaq. There's a Japanese one that name I've forgotten, and then there's a Jewish dissolution as well. Those religious dissolution of marriages will fall under other processes or other proceedings. They are not proceedings per se, but because in the eyes of the English courts, they don't fall within the test of proceedings. However, as I've argued,
right,
you can lift the customary law dissolution which took place either in the chief's palace or in the family home or through an arbitration and make it satisfy the English requirement under section 46(1), which is that it becomes a proceedings. There's a case law that I refer to, which is a Pakistani case. It's a case of 𝗥𝗲𝗰𝗶𝗄𝗏. 𝗥𝗲𝗰𝗶𝗄𝗏 which is the talaq, which is the Islamic process of dissolution. But in Pakistan, in addition to dissolving the marriage through the talaq, you also must register it through the Islamic register of divorces. So that once that is done, they accept your marriage as being dissolved. For that reason alone, the Court of Appeal held that the processes that they went through can be uplifted under section 46(1) to a procedure or proceedings under 46(1). In the same vein, I'm arguing that because our Marriage Act of 1873 to 1985 under customary divorces prescribes a registration. If your customary marriage was registered under the customary law, then it is mandatory. It is mandatory that that dissolution, whether at home or by chief's arbitration, must be registered with the local authority, which we call that the district assembly or the metropolitan assembly. In those regards, we would say that if a Ghanaian who is habitually resident in the UK but domiciled in Ghana because it's domiciled by birth or domiciled of origin, that Ghanaian can still use the otherwise process to show that he's free to marry in the UK because his marriage has been dissolved under customary law in Ghana.
Okay.
I think it's a matter of explaining exactly what has happened and referring to the law, which is the Marriage Act, and the reason why you believe that because of the requirement of registration, it takes an otherwise proceedings and makes it a proceedings.
Now, to the ordinary person, the question then will be that it does not necessarily mean that if you dissolve your marriage outside of the UK, it will not be accepted here in the UK. Is that correct?
Absolutely right. So your divorce in a foreign country, and we're using Ghana as a test case. If your marriage was dissolved in Ghana and it was dissolved in court, either by confirmation of the customary law dissolution or under both under the matrimonial causes, that is valid in the UK. But if your marriage is dissolved by your family and you take the extra step which is required under the Marriage Act to register that divorce with the local authority, again, my argument is that that lifts the otherwise process and makes it a process. Again, that dissolution will be valid under the English law, although you may have been habitually resident in the UK because you've lived here for more than 12 months or so.